The first speaker is David Spector. David Spector is a partner in the West Palm Beach office of the Akerman Senterfitt firm. David's practice focuses on complex litigation, including contract, fiduciary, and fraud litigation, unfair and deceptive trade practice, and professional negligence litigation. Today, David will address the ethical morass facing in-house counsel. Welcome, David.
All right, well, thanks very much. We have a fair amount of topics to cover, so we're going to move fairly quickly. But I added a slide yesterday or 2 days ago that I emailed to Ed because I figured it highlighted the exact risk for in-house lawyers. So for those of you that haven't seen this, here was an in-house lawyer that creatively created a fake law firm in which he was paying significant amounts of fees. If you look at the bottom there, this in-house lawyer who's now on the run, so I figured this would be the start on the things that you should not do if you're an in-house lawyer, is to create a fake law firm and funnel out almost $10 million in, quote, legal fees to you and your wife. So let that be the start of probably, hopefully, the worst that we're going to see for in-house lawyers as we move forward a little bit and showing the risks that you have. Let's talk a little bit about the ACC's recent 2011 census report, which really kind of tracks the frequency and the use of outside counsel, issues, and what we're seeing. First of all, there was 5,800 in-house lawyers that responded to the ACC census this past year. Okay, 4,100 separate companies. And if we look at some of the shifts in what in-house lawyers are seeing on a day-to-day basis, there's a lot of things that have changed. Obviously, with what the economy has done, in-house lawyers are facing different types of pressure. It used to be thinking that more things were coming in-house. Now I'm going to show you some statistics that show that's probably changed a little bit and things are going back out to outside counsel. We know that in-house lawyers are using less law firms, right? We hear that all the time. We don't want to have as many law firms out there. We want a smaller set of firms that can do more for us. But if you look through at some of these bullet points, all of these are placing additional concerns and risks to the in-house lawyers. You don't have as much money. You don't have as much staff. Are you a lawyer or are you a business person or are you both? And we're going to talk a little bit about what that means about the privileges that you are going to try to assert during the course of litigation. You have more claims, decrease now in outsourcing and use of outside counsel for litigation. More litigation is being managed in-house. We know that from a regulatory standpoint, particularly if you're in the financial services industry, if you're publicly traded and you're dealing with Sarbanes-Oxley and other areas, you have increased significant risk. Okay? You have owners, if you're in a more closely held corporation, that are watching over everything more than they have. And now we have a resurgence again in M&A activity. So your jobs as in-house lawyers have become increasingly more difficult. You know, the whole thought of going in-house to work less, make a little less, but work a lot less, I don't think that's really true. If the more you talk to your clients about are they working less, you know, the in-house lawyers that I deal with are there late as late as we are and as early as we're coming in. So the landscape has really changed for what it looks to be an in-house lawyer. Looking a little bit more at the statistics specifically, you can see the shift. The lighter blue is 2006. The darker blue is 2011. Okay, so here's a decrease in outsourcing dramatically on tax issues, but you know we're here to talk about litigation. So the first three bars are interesting, but litigation has only decreased slightly, but the volume of litigation has increased dramatically, is what we're hearing from most in-house lawyers. So interesting change in landscape, and if these trends continue, that's going to highlight the even more significant role the in-house lawyers are going to be playing in the management of litigation. All right, so let's talk a little bit about what the model rules say. For those of you that are confused and don't believe that the model rules apply to you as in-house lawyers, you are gravely mistaken. The very same model rules or your state local rules that apply to outside counsel apply with equal force to in-house lawyers. We have seen a spike of grievances against in-house lawyers and claims being brought against in-house lawyers for violations of the disciplinary rules. So we all know the basic rules of Model 1.1, right? A lawyer shall provide competent representation to a client. What does that mean? It's legal knowledge, it's skill, it's thoroughness, and preparation reasonably necessary for the representation. The comment to ABA Model Rule 1.1 makes it very clear. There is no different rule that will be applied to an in-house lawyer than will be applied to an outside counsel. Okay? The model rules also specifically include the definition of a law firm to include the legal department of a corporation or other organization. So there is no question under the law that these rules apply to you. So when you're talking about how you're going to pick counsel, how you're going to manage your claims, you are subject to the same scrutiny, at least as far as the bar is concerned. And we can talk about what the standard of care would be for a reasonably prudent lawyer. I mean, the general standard of care in a legal malpractice case is what would a reasonably prudent lawyer do in that legal community. Okay? So what I do in Florida is not necessarily the same standard of care as in New Jersey, because you have to look at the community. But you're an in-house lawyer, and there's an argument that the community doesn't change by geography, it changes by where and what type of a department and what type of a company you're working in. Okay? So the rules get a little bit more complex. Hiring lawyers is good, but it does not absolve you of your duty to your internal client. Okay? You may be the outside lawyer's client for all intents and purposes, but your client is your entity for most purposes. You know, we're going to talk about Upjohn and a little bit how that plays into it. But you have got to understand that those rules apply equally to you. You know, what does it mean when we talk about competence? Competence, it's not up on the slide, it's generally looked at as the relative complexity and the specialized need and the nature of the matter. Are you competent for that type of specific matter that you're undertaking? What is your general experience, generally? What is your training and experience in that field? So if you're defending a products liability lawsuit and managing that in-house, are you competent to do that based upon your prior experience, or have you never defended that type of a case before? Okay? And the preparation and study of the lawyer. What did the lawyer do to get up to speed? If you're an in-house lawyer and you're relying solely on your outside counsel to do everything, but you do have a duty still to that internal client, you're probably not fulfilling that last prong, which most of the courts around the country have adopted. Let's look at some of the issues that we're seeing now that in-house lawyers are facing. The first thing is e-discovery and electronic preservation. I know there was some discussion of it earlier on the duty to preserve, but let's look at some of the recent cases, and we all can talk about Zubilaki and everything that we've been hearing for a long time. But these rules apply equally to in-house lawyers as they deal with outside counsel. In the Swafford case, which comes out of Florida, and the parenthetical is that, yes, sanctions were imposed against an in-house lawyer, but you have to understand what happened. The plaintiff sent preservation letters very early on, pre-suit, and no one it was a general counsel's office of a sheriff's department, did anything to preserve. The in-house lawyer had to testify and said, we got the letters, we put no preservation efforts until the very end. Yeah, I sent out a generic litigation hold, but when questioned, and the court did some of the questioning there, well, what did you do to actually follow up with your departments to make sure that they were actually implementing the hold and make sure that they were preserving? And the answer was nothing. Okay, so the in-house lawyer, as an officer of the court, was therefore subject to the sanctions by the court and resulted in significant monetary sanctions and an adverse inference, which was given to the jury at the end of the case. The court had a statement that said nothing other than bad faith can be inferred, and then reference to the fact that the general counsel of that entity decided to do nothing. Okay? So you are putting yourself at risk when you decide to outsource entirely the litigation hold process. You must ensure internally that your internal client does what they're supposed to do and follows through with the edicts that your department has issued. In the Arizona case, there was a very similar fact pattern. The in-house lawyer had received pre-suit notice from the plaintiff's bar that lawsuits were going to be filed. But here they didn't even issue a litigation hold. They did nothing on it. So they didn't follow their standard procedures, okay? And what the court said, that an in-house lawyer is obligated to impose a litigation hold and suspend auto deletion at the first time that they get notice that they may get sued. Waiting till you get that summons and complaint isn't sufficient. You have notice on it as a lawyer under your duty of competence that you owe it to your internal client. You have an obligation to implement that hold and start those procedures. Okay, some of the statements there, again, from those cases, you must take affirmative steps to monitor compliance. You cannot be passive. If you are being passive, you are arguably violating Rule 1.1, and you are not providing the quality representation to your client that you owe as a matter of law. Okay, and both of those cases are very good ones on the e-discovery retention period piece. A very recent case that came out, only a few weeks ago that we saw it. Here, in this case, in 2004, the Eaton company was sued involving a trade secret of about $1 billion worth of damages. The suit was dismissed in 2010 for alleged improprieties of its lawyers, including the inside counsel. Okay. There were some other issues, as you can see. There was an attempt to influence a presiding judge, but as a result, there was a counterclaim that got filed, and those lawyers, after an in-camera inspection of four pages of newly discovered emails, ordered the CEO and the in-house lawyer to provide affidavits explaining why those emails weren't originally produced. For those of you that are following a little bit what's going on in the TD Bank litigation in Florida with Greenberg Traurig, there's a big issue over right now in federal courts as to the obligation to preserve and what you are going to do when you newly discover emails and what is your obligation to bring them before the court. It goes without saying that if you find stuff that was withheld purposely by your client or inadvertently, you have an obligation to immediately produce those. But that obligation doesn't only run to outside counsel. That runs to you as an in-house lawyer who's an officer of the court and who's governed by our same rules. All right. Here is just simply, and it's in the handouts, a chart to show you, for those of you that are familiar with metadata, the embedded data that are in certain types of files. The courts around, the states around the country have a little bit differing opinions as to when metadata, what your duty is, and when you have to scrub it before you do. So we've just kind of, I'm not going to spend a lot of time, but here's a chart that summarizes all of the states that talks a little bit about metadata. All right. So we talked a little bit about what we're seeing trending-wise in the census report. There are a few ABA opinions that you should realize. 08-451 from a few years ago makes it very clear, for the extent that there were some courts that were not clear. The ABA's position is that outsourcing does not abrogate your 1.1 obligations, and the rules 5.1 and 5.3 require lawyers to make reasonable efforts to ensure that the lawyers you are hiring are following the rules governing the lawyers in that state. Okay. In 451, the court actually, which is a standing committee on professionalism, looked at some factors as to whether an in-house lawyer and how an in-house lawyer is exercising those duties. Things that they specifically state you should do when retaining outside counsel and outside vendors. Reference checks. How many of you do reference checks on your vendors? How many of you do reference checks on the lawyers you're hiring? I'm going to say that probably very few of you are. Investigate, for example, if you're using an outside company to do a large-scale document production. Is the security sufficient at the location that you're doing it? What about when you use an e-discovery vendor and you take 2 million files and you dump it on whoever that vendor is so they can load it into Relativity or whichever one you're using, and they manage your data? What are you doing to make sure that your data is protected? Because there are cases out there that suggest that when the data is compromised because of something that the vendor did, or worse, if you're doing it offshore, if you're using a company that that ethics opinion actually says you should think about getting up off your chair and going to that location to make sure that they have proper security. Because we're going to talk about violations of Rule 1.6, which is your duty to maintain client confidences, which are violated. Okay, and if stuff gets out, that's going to wash back on you. I'm going to show you the cases that detail that. So the other thing that you need to talk about also is informed consent. You make a decision, right, to say, okay, I'm going to hire David here. I'm going to give him carte blanche. He goes out and hires e-discovery vendor XYZ. They put that in a location that's compromised. And at the end of the day, when it all goes bad and you get grieved and the bar says, well, let alone David, but did you as the in-house lawyer have informed consent from your client that you were taking that data and giving it to someone offshore where you didn't know where they were, you didn't know the security, you didn't know the background, and if you didn't get informed consent, you could get disbarred. Because that's what the states have started to do, that the grievances have been upheld because the obligation runs equally to you as in-house lawyers. All right, so we talked a little bit more about providing information concerning the outsourcing relationship. There's an earlier from 1988 ethics opinion that we cite in here that the implied authorization that you have to share information within a law firm does not extend to outsiders. So those rules are different when you're dealing with internally in your law firm versus outside of your organization. All right, let's talk a little bit about assisting. I've got 3 minutes left. That's incredible. All right, about assisting. There's just too much to talk about here. About assisting clients with fraud. Can I have like 5 more minutes? I didn't think so. Yes, I like it, but Ed won't allow me to. All right, so we all know the rules. You cannot assist your clients in fraud. Get it? It's not very complicated. But if we're going to show you some of the cases, I already pushed the button. You're not going fast enough. In this case, an SEC case involving this lawyer, Fain. Fain was going to was helping a client investigate a 10Q issue in their SEC filings. He knew there was a problem. He based his subsequent 10Q filings based upon bad information that was in the pre-existing ones. Okay? He edited them and he resubmitted them. The SEC then brought suit against Fain to enjoin his aiding and abetting violations of the security laws. He said, well, wait a second, I acted in good faith. I didn't know, I didn't prepare that first 10Q. Well, that's great, because that defense was rejected as a matter of law. Because if you have a reason to know that the information that went in initially is even bad, even if you didn't participate in the fraud, and you continue and prepare publicly traded filings based upon that bad information, you should be expected to get sued and be a defendant by the SEC in an enforcement action. Okay? Rule 2.3, again, if it's incompatible with the responsibility to perform an evaluation for others concerning the same, okay, you cannot do that. That is going to be aiding and abetting that type of fraud. We're going to go past some of the SOX rules because it doesn't, there may not be a lot of information here. We know the general concepts of 1.6. You got to maintain the confidences of your clients. Okay? When can we disclose that? When does that not apply? Well, it applies that if you get grieved, you can disclose that. If you get sued, you can disclose that. And if you get brought up on criminal charges. So let's talk a little bit more about criminal charges. Here's an in-house lawyer at Glaxo who relied on King and Spalding lawyers, if we look at the next slide, to provide information about an off-label use for a particular drug. And the government concluded afterwards that she knowingly provided false information and charged her criminally. Okay? The court ended up entering an order of acquittal prior to trial and said that he could not conclude that that there could be an inference of guilt. And the reason why is that she had given that information to King and Spalding lawyers who had then drafted the information for Glaxo to provide to the government. But this is one of the first cases that we have seen where there were criminal charges that were filed against the in-house lawyer for information given in response to a governmental inquiry. I've talked to people, friends at the U.S. Attorney's offices around the country in another seminar, and they all said they all have some cases that they are looking at charging in-house lawyers at providing false information in the context of a governmental investigation. That is a real concern if you are responding to the government right now. All right, protection of confidentiality. Let's talk a little bit in a deals transaction. Whose privilege is it? Okay, we all know, and I have some slides later on that I don't think we're going to get to about how the privilege, it depends if are you a business person this day or are you a lawyer that day. And it really is very fact specific, and it's got to be in responding to a request for legal advice. But the courts around the country are pretty uniform that if it is a stock sale, if it is a true merger, okay, that privilege passes to the purchaser. That privilege is held by the purchaser. So if the purchaser then wants to find out what was discussed with the lawyers, sometimes even with regard to that deal, it may be fair game. If you have an asset sale, as you can see in the second case, generally that does not pass to the purchaser, although there of course, like in everything, there's the outlier in the cases. Here is that a purchaser in an asset deal does control the privilege with respect to the communications of the purchased assets. There, they were purchasing the rights to pursue certain patent infringement cases. They were actually buying the rights to these cases, and the court said in that context, even though it's an asset sale, that privilege is going to pass to the purchaser. So when you're talking about drafting your deal documents, if you're an in-house lawyer, address it in your documents. There's nothing wrong with saying, here's who's going to hold the privilege. And we're going to bargain for that now. You're not going to hold the privilege as to certain things. You may hold the privilege as to others. But frequently, when I talk to in-house lawyers, it's never even addressed. And you know what? That's a violation of the in-house lawyer's duty of competence to the client. because the case law is out there and will suggest that you need to think about that when you're crafting your deal. A little bit more, we're going to go a little bit fast on these issues, talking about what's going to be in those deal documents so we can talk to some of the more recent cases involving 1.6. The In re Google case, which really talks a little bit more about the privilege specifically, was a piece of litigation between Google and Oracle. In that case, the court had to examine the issues of was the advice given in context of a legal dispute, or was the advice given in the context of a business dispute. And in that case, the court held that on a fact-specific inquiry, as well as in the Kincaid case, that the communications were not privileged, because here was a business person giving alternatives to negotiations. Alternatives to negotiations are not legal in nature. The courts have concluded that if you are telling your client how to get, your internal client, how to get an upper hand on a negotiating tool, that's not legal advice, okay? In the Google case, they were talking about whether or not they were going to have to move away from Java, the use of the software in the context, and I see the time, in the context of a dispute over whether or not Google was violating Oracle's patents. And they had a discussion with some of the in-house engineers, real business people, over what could we go to, what other platforms could we go to. And the court ruled those were not privileged. That's not legal advice. Business advice on how to get the upper hand in a deal is not business in nature. Now, there are ways to craft it. If you're responding to a specific inquiry where they're asking for legal advice, there are ways to better protect your privilege, and in all of these cases, that failed. Lastly, for those of you that are providing work overseas with the European Union rule, the courts have held that the attorney-client privilege does not attach to communications with an attorney who holds a position of employment with a client. The rules are very different overseas. So the stop button and the buzzer and the trap door is about to open underneath me. So with that, I'm gonna give it on to the next person, and I will be here if we can answer any questions. Thanks very much.